क्या होता है अगर लैंड एक्विजिशन प्रोसीडिंग को लैप्स कर दिया जाए? हाईकोर्ट अगर अपने आदेश से ऐसा करती है तो क्या स्थिति होती है, ये देखने के लिए हाईकोर्ट के कुछ आदेशों का स्टडी करना आवश्यक हो जाता है। देखिए, 226 आर्टिकल 226 में फर्स्ट एंड फॉरमोस्ट ड्यूटी ऑफ द ऑनरेबल हाई कोर्ट इज टू मेंटेन एन इक्विटी, a balance between the petitioner and the respondents. In such situation where due to any fault or due to any error or any lacuna or lapse on the part of the acquiring body, if High Court finds that land acquisition proceedings pertaining to a particular subject land is to be quashed or is to be deemed lapsed, in such circumstances, whether the land would revert to the landholders or what would happen here. Just imagine a situation. An interesting situation came before the Honorable Apex Court that the notification under Section 4.1 was issued on just before the that's called enforcement of the new Act of 2013. See, let me specify the dates. Section 4.1 notification was issued on December 27, 2013, and you know that new Act of 2013 came into force from 1st January 2014. So in this case, the notification was issued in the 27th December 2013. And publication of the said notice was done on 2nd and 3rd of 2014, and a public notice in the locality was done on February 6th, 2014. So what happens here? The Supreme Court came to the conclusion that since the publication of the notices took place after the enforcement of the new Act of 2013, that is after 1st January 2014, therefore the land acquisition would lapse. But instead of quashing the notification, the court arrived at a proper balance, holding that since the proceeding had taken place long back, certain parts were developed, and the question involved was only for a small areas which was to be constructed and converted into a road. So the Supreme Court arrived at a conclusion that it would be better to compensate the landholders at the rates as provided in Section 24.1 of the new Act of 2013, instead of declaring the land acquisition proceedings as lapsed. So